you for joining us this morning. This is a pre-recorded section. This morning's topic is power of attorney and guardianship, and we're going to be learning a lot about the differences and what those topics mean, as well as some other key information regarding protecting individual rights. We're very fortunate to have Melissa Keys, who's the legal director of Indiana Disability Rights, with us this morning, and she's going to go ahead and talk to us about these topics and what they mean. So, Melissa, if you're ready, I'm going to go ahead and make you the presenter.
Great. Okay. Can you see my screen?
Yes.
Okay. So do you see my slides?
I see your kids.
Oh, okay. Hang on. Do you see it now?
Yep, it's very small.
So I have a dual monitor system working, and so I wonder how to, oops. Let me see if I can just move it over here. Sorry. Again, this is me fumbling with technology. Can you see it on that one?
Not very well. It's still really small.
Oh, goodness. Ew. Maybe that works.
There you go.
Is that one? Okay. Look at me figuring it out. Okay. So, good morning, everybody. My name is Melissa Keys, and as Amy said, I'm the legal director for Indiana Disability Rights. I have a master's degree in clinical psychology with a focus on developmental disabilities and serious mental illness, as well as a law degree with a focus on legalese and wrench throwing and table banging. So, between the two of them, I've got this area pretty much covered, including crushing student loan debt. So, today I am going to cover some basics on decision making, and then we'll focus on options that are available to adults to assist them with decision making, specifically spending some time on supported decision making, and then finally we'll end with how you can help to make sure that people are receiving the help they need in the least restrictive manner possible. So let's start out really simple. We've all made decisions. In fact, we make hundreds, if not thousands, of decisions every day. What to eat, what to wear, whether to answer a snarky email with an equally snarky email. And the decisions that we make range in their complexity and the time and the mental resources that we use to make them. So for example, the time and energy that it takes for us to decide what to eat for breakfast is different than the time that it takes to make bigger decisions like where to live or whether to take a new job. But regardless of the type of decision that we make, the process is really still the same. It involves understanding the issue, determining the options and consequences, gathering information, evaluating those different options, deciding on a course of action, communicating or implementing that choice, and then experiencing or observing those results. Now, sometimes this process is instantaneous. We don't even realize we're doing it, like deciding what to wear. Other times, we are much more deliberate. We talk to friends and family, we talk to trusted professionals, we read Amazon product reviews. We do whatever is needed in order for us to feel comfortable and informed in making our choice. And we are empowered to make that choice and have our decision respected. And that's part of the natural human experience of how we make choices. Now, we have all had experiences, even as adults, where someone has made a choice for us. For example, you want Mexican for dinner, but your partner orders Chinese. Even those small choices, when we feel like we haven't been heard or that our choice hasn't been respected, can make us feel really frustrated. So then think about the big decisions in your life, what job you have, where you live, how to spend your free time, who to spend your free time with. And imagine how it might feel to not be able to make those choices about those important areas of your life or to not have input. So Indiana just passed a law formally recognizing supported decision-making as a less restrictive alternative to guardianship. Part of that law includes a definition of supported decision-making that states, supported decision-making refers to the process of supporting and accommodating an adult in the decision-making process to make, communicate, and effectuate life decisions without impeding the self-determination of the adult. So, what lawyer came up with that one? Actually, this definition is based off of similar definitions that are used by the National Resource Center for Supported Decision-Making, as well as Massachusetts, Maryland, District of Columbia, Texas, and Wisconsin. But so what does that mean in real life? In its most basic understanding, supported decision-making is a way to accommodate that decision-making process that I just talked about. So in SDM, people who need support, they choose supporters. These are generally trusted friends, family members, could be caregivers, to help them through that decision-making process. However, with supported decision-making, the person has all decision-making authority. They retain that right to make the decision themselves. It's a way to increase empowerment. It's a way to assert self-determination. And for those who may need assistance with the decision-making process, it allows them to keep that independence without having to jump to a more restrictive option. And here's a kind of an example. So the other day, my husband let me know that he and some other dads from the neighborhood were going to start a bike gang, like, bicycles, not motorcycles, which is the most suburban dad thing you can do. And he asked me, should I wear a helmet when we go on our bike ride? And my immediate mom response was, of course, yes. The risk of, traumatic brain injury versus looking cool in front of your friends is a no-brainer. And we talked about some pros and cons, potential consequences, but ultimately he made what I would consider to be an unwise choice to not wear a helmet. Not the safest choice, not the choice I would have made, but it was his choice nonetheless, and he was empowered to make that. But as adults, we get to make decisions, even bad decisions, all the time, and those decisions are respected. When he went off on his bike ride without a helmet, police didn't come and take his bike away. Somebody didn't say, you can't ride a bike like that anymore. He was allowed to make a choice. And this is an example of supported decision-making. He used me as a supporter, and that's the cool thing about SDM. It's what a lot of us do already, and it's how most of us make major and sometimes even minor decisions. Now, of course, riding a bike without a helmet is not the same as whether to get a potentially life-saving medical treatment. But no matter what that decision is, how much support that person needs or the type of support they need, it's so much better to support someone to help them make the decision themselves instead of making a decision for them. So people often ask for examples of the types of support or accommodations that someone can have under supported decision-making. And this is really difficult because it can really be anything. But to give you guys some examples and some context. So we look at that understanding the issue. Maybe they need help explaining it to me in English. Doctors often use big words. Lawyers use big words. And sometimes helping bring it down to a level of understanding that the person can understand can help them be better able to make the decision themselves. So for determining options and consequences, help me see the big picture. Help me see how this fits into my overall view of my goals and vision for how my life looks. For gathering information, it could be, help me write out what questions I need to ask, or help me figure out what are good sources of information. When you think about evaluating options, help me make a pros and cons list. I'm a huge list maker. Help me express my values. If you happen to know that I really value hard work, or I really value community, being involved in my community, then help me understand, is the choice that I'm making consistent with that value? And then making a choice, help me get unstuck. There's plenty of research that shows that people with autism spectrum disorders or serious mental illness or other types of conditions often feel stuck, especially in the immediate moment where they may feel forced to make a decision. So, help me recognize when I'm feeling stuck, or help me advocate for being able to take some time to think about what I need to do next and make that choice later when I'm unstuck. And then when you think about, communicating or implementing that choice, help me to express my choice, help me to understand what I need to do next. And I put an asterisk next to help me express my choice, mostly because if the person wants to express their choice or wants assistance expressing their choice, and they themselves are not going to be present, then you would most likely want to also have a power of attorney that would give the supporter the ability to communicate that choice on behalf of the person. But we'll get into that in a second. And then observing results. Support the choice I've made, whether or not you think it's a good choice or a bad choice, whether it supports your values or not, but just support the choice I've made. So what are we really talking about when we're talking about making our own decisions? We're talking about self-determination, and self-determination is really central to the human experience, and there's been a growing body of research about the benefits of supporting self-determination. So for example, there's been shown to be improved psychological health, better quality of life, more integration with community and community-based employment, increased health, welfare, and safety measures. However, the converse is also true. When people have been denied self-determination, there's been research that shows that they experience low self-esteem or passivity or feeling of inadequacy or incompetency. There was a research study done that said that people subjected to overbroad or undue guardianships can experience significant negative impact on their physical and mental health, their ability to function, and their subjective well-being. And so that's why it's really important that as much as possible that we preserve and promote that person's self-determination to the greatest extent possible. So, who can use supported decision-making and other less restrictive alternatives to guardianship? So the short answer is really anyone can use the principles of supported decision-making. The concept can be used by anyone to help maximize their participation, even for someone who's currently under guardianship. As we talked about, it's not so different from how we all kind of make major and sometimes even minor decisions, relying on the people, relying on our circle of support, relying on friends and family members to give us that feedback, give us that help and that assistance. So while the concept of formalized supported decision-making really kind of started with people with intellectual and developmental disabilities, can be used for any disability, any condition, including those with mental health issues, those recovering from addictions, traumatic brain injury, those with conditions of aging, anything really. And the law in Indiana really opens it up and allows anybody, not just a person with a disability, to be able to use this type of tool. So I want to talk really briefly about this issue of capacity, because there are different legal standards for capacity. There's capacity to consent, capacity to contract, capacity to sign a power of attorney, and it's really important to note that capacity exists on a spectrum. So whether someone has quote-unquote capacity is determined by the situation, the complexity of the issue, as well as some internal and external factors like time of day or physiological state. For anyone who's ever gone grocery shopping hungry, you understand that you make different choices than you do when you go shopping and you're not hungry. Timing of day might also be important. You ask me a question before 8 a.m., you're going to get a much different answer than you will when it's 10 o'clock at night and I'm kind of in my zone. And it also relates to the person. Their alertness may change based on when and what type of medication they've taken, how much sleep they had the night before, the season or time of day. All of these different factors can go into whether or not somebody has the ability to answer or to make a choice or to communicate that choice. Capacity can also change over time based on skill acquisition. So the more you learn or practice a particular skill, the better you are at it. And the same is true for decision making. So for example, I have a driver's license. So this means the state of Indiana has said I have the basic capacity to drive a car. In order to demonstrate that capacity, I didn't need to prove that I knew everything about how a car engine was built. I didn't need to drive like Danica Patrick around the 500. I just needed to meet those minimum requirements to show that I could drive safely without, hurting myself or others. Now, my driving skills, for the most part, have gotten better than they were when I was 16, right? And there's also been advances in technology that's made it easier and safer to drive. But my capacity to drive even still fluctuates. So driving late at night in bad weather with my kids screaming in the back seat is much different than driving on a clear day. I'm on my way to Target, Beyonce's on the radio, and I'm just, living my best life. But the state of Indiana hasn't put restrictions on my ability to drive. They haven't said you can only drive, on clear days when Beyonce's on the radio and you're going to Target. They also haven't said, you need to know how to rebuild a transmission and you need to know how to drive all sorts of cars trucks, planes, boats, in order to be able to have that right to drive. It's understood that I can seek help for those issues that are outside of my wheelhouse, and that I can consult with professionals who know much more about a particular area than I do. The same, unfortunately, isn't always true for decision making. Oftentimes, people with disabilities have to prove that they can make decisions covering a wide variety of areas and complexity at all times and under many different circumstances in order to maintain or even prove their ability to make decisions independently. And so the point is, when we talk about capacity, when we talk about somebody's ability to make decisions, we really need to think of it as a spectrum, not a yes or no, keeping in mind all those different factors that can go into a determination of whether someone has capacity or not. So another question that I get is, oh, I know someone who this would be great for, but he doesn't have any family or people in his life. So let's talk a little bit about how to help people who are, quote unquote, without supporters. So it might take some creativity. If the person doesn't have people readily identifiable to serve in the role of supporter, or to serve as an attorney, in fact, under a power of attorney, or to serve as guardian, you may have to be creative in thinking of some different options. So think of former service providers that they really had a good connection with, maybe former teachers or neighbors, parents of their friends. There's some really cool research being done with peer-based decision-making and crowdsourced decision-making, but keeping in mind that there doesn't have to be one magical person that serves everything to that one person. You can have multiple people. So for example, if they have a neighbor and the neighbor is willing to provide advice and support on how to keep their house up or how to maintain their house, or check in on them every once in a while, that doesn't mean that that neighbor also has to help them be responsible for finances or employment issues or services and supports. You can really kind of structure it to help the person figure out how to best meet their needs using the resources that they have. And there's also looking for meaningful opportunities for the person to develop those relationships. If the person likes bowling, help them join a bowling league, and not just a Special Olympics or something like that, but integrating into the community. Do they like reading? Have them join a book club at the library. And finally, there may need to use other options like power of attorney or limited guardianship or guardianship if the person's unable to really find a good circle of support to help them. So let's talk about some different options that might be available. So we've all been there where we've been in a meeting where someone has said, once the child turns 18, parents have to get guardianship or else they won't be able to participate. And this happens in education, this happens in medical, this happens in service provision. It happens a lot, but with very, very, very limited exceptions. There are no services or supports or benefits that require someone to be under guardianship in order to access them. And I want to make sure everyone's aware that there are options other than guardianship. Now, don't get me wrong, guardianship is definitely a necessary tool. But for those who are just getting guardianship to be able to participate in a loved one's life, there are other less intrusive ways to do that. So our goal here, again, is just to make sure that everyone has an opportunity to participate, make decisions about their life to the greatest extent possible, and in the least restrictive manner possible. So let's talk about some of those different options briefly, how we can help support people, keeping in mind that many of these tools can be used in combination, or they can change over time, to really individualize the supports based on the person's strengths and needs. So I am a very visual learner, so this makes sense to me. This is what I call the spectrum of assistance. It goes from the least restrictive to the most restrictive. The green categories are things that you should be able to do freely. You can move into and out of them. You don't have to, do anything fancy. You can just kind of be creative and work on them. The yellow ones are things that you should consult with an attorney who's knowledgeable in the area so that you make sure that the documents that are being drafted are done so in accordance with the law and the person's wishes. And then obviously the third category are things that you really need court involvement, and that involves a whole other level of intervention, resources, money, perhaps legal counsel, that type of thing. So starting at the top with least restrictive, looking at independence, or some people like to refer to it as interdependence, as well as, informal supports. And these are really ways to help fill the gaps in someone's needs. So for example, someone who has a hard time remembering to pay bills, you could set up automatic bill pay. There's credit cards with low limits. There's credit cards where you can restrict access so that they can't purchase things over a certain limit, or they can't purchase more than a certain amount from a particular store. There's all kinds of tools for those who need help with budgeting. There's all kinds of smart apps, smart home technology. There's pill dispensers, there's pill services that will deliver prepackaged pills so that the person doesn't have to worry about knowing whether or not they took their pills that day. There's smart home technology that allows people to remotely lock and unlock doors if they're worried about forgetting to lock things up. There's services that will help open mail to ensure that bills don't get lost. There's dog walkers, grocery delivery. There's all kinds of things to really help support a person to live independently as much as possible. So here's kind of a brief example. So my friend Jamie moved from Richmond to Muncie, and she had to learn how to navigate public transportation. So, instead of putting in her service plan that, Jamie will memorize the bus schedule with 80% accuracy over a 2-week period, Jamie learned how to navigate around Richmond using Pokemon Go, which is a game that gets people out and walking around to look for and hunt for Pokemon. And she used that to learn the streets, learn how the city was laid out. So the next category, we've got formalized supported decision-making, which again, is a way to accommodate that decision-making process that still allows the person the ability to make the decision themselves. So the person chooses not only the areas where they need support, this could be, finances, health, services, education, employment, community living, whatever. The person also chooses his or her supporters. Again, those are generally trusted friends or family. And then they also choose how they want that support to be given. For example, giving the person information in a way they can understand, or helping them discuss the pros and cons of a particular choice. The formalization of it generally means, writing down the person's plan into a document called a supported decision-making agreement, which we'll touch on briefly in a moment. The supported decision-making arrangements can be changed as needed. They don't require a court to get involved. Next are agency agreements, where a person has the capacity to appoint someone else to make decisions on their behalf. This is what you typically think of for things like powers of attorney, healthcare representative, possibly even representative payees. And depending on how that document is written and the type of document, the person can delegate their decision-making authority to someone else. They can be written to address any number of circumstances. They are flexible, they're well-regulated. Powers of attorney are useful, but they differ significantly from supported decision-making in one major way. So in SDM, the person retains decision-making authority. The person works with their supporter, but ultimately they make their own decision. There is a tendency, even with some of the most carefully drafted powers of attorney, to revert to its common context and assumption, namely that the attorney in fact has been granted decision-making authority, or there's a tendency to think that a springing POA has been sprung, or some people will see that POA and assume that it creates an agency relationship and takes away the person's ability to make the decision themselves. POAs can generally be revoked by the person unless they no longer have capacity to do so. They generally also do not require court oversight or involvement. They're also just a good practice to have in place for anyone as part of general, advanced planning. For most of these, it's really wise to consult with an attorney to make sure the document complies with any relevant laws and that it's drafted in accordance with the person's wishes. So guardianships are obviously a legal process involving courts. There are a few different types, but I want to be clear about what it is. There are considerable rights removed from the person as the guardian essentially stands in the legal shoes of the protected person. This should be used when a person can no longer make or communicate decisions about their life or their property. And like I said earlier, guardianship is absolutely a necessary tool, but for those who don't need that level of intervention, we want to try and focus on less restrictive ways to help give them the support that they need. So real briefly, protective orders are ways for a court to ratify a particular transaction. So for example, if someone inherited a large piece of property and they needed to dispose of it rather quickly, but the bank was concerned about the person's ability to consent to that transaction, a court could issue a protective order regarding the disposition of that property to allow that transaction to take place without the person having to go under guardianship in order to do that. Temporary guardianships is where a court can grant decision-making authority to someone for a very limited amount of time. It expires after 90 days, or if you show cause, you can get it extended for an additional 90 days. These might be useful for issues regarding discharge or admissions if that's needed. Limited guardianships are guardianships generally over either just the person, meaning dealing with issues about where they live or their medical treatment, or over their estate, which deals with things like property or assets. And so in the areas covered by the limited guardianship, the guardian makes all the decisions, but the person retains decision-making authority in all other areas. And then obviously full guardianship means that all decisions, both person and estate, are made by the guardian. Now, the thing to keep in mind about guardianships is they are pretty difficult to terminate. There's only two ways that they terminate in Indiana. One is death of the person under guardianship. The guardianship does not terminate if the guardian passes away. In that instance, the court will look to successor guardians or temporary guardians to fill the role until a full guardian is replaced. The other way to get out from under a guardianship is by showing through clear and convincing evidence that the person has, quote unquote, regained capacity. This can be very expensive, very time consuming. It generally involves needing to have medical testimony as to the person's capacity, and that's why it's really important to start with the least restrictive option possible before moving up. So I just wanted to note briefly, there are lots of other decision-making models out there. There's shared decision-making or team-based decision-making, where the decision is kind of made by the person in coordination with others. You might think of this with like treatment planning or case conferences. There's also shared decision-making concept in the medical field to help promote informed consent. There's also other support arrangements. There's trust accounts and advanced directives and psychiatric advanced directives and living wills and all kinds of ways to help support people to be able to give them the structure and support that they need while helping them to promote their independence and self-determination as much as possible. That's why people should really be encouraged to talk to an attorney who specializes in this area of law so they can discuss all the different options that are available. And then one thing that I also want to note again is this concept of supported decision-making, of accommodating and supporting someone through the decision-making process really can and should be used throughout any of these other options. So even used within the guardianship context, it can be a way for the person to gain skills in decision-making, which could eventually lead to less of a need for a guardian or a less restrictive option. So maybe moving from full to limited might be an option. And when you're looking at options, there are a lot of different types of assessments out there to help someone, kind of hone in on their strengths or the areas where they might need some of that support. If you're interested, you can send me an email. I can share with you a list of resources or share with you the assessments that we use. The point is you want to look at the person as a whole. What areas of decision making are they already doing? What could they be doing with some support? Are there skills they can learn in order to be more independent? These are all things to really keep in mind as people are exploring the different options that might be available. So I want to focus briefly here on the difference between power of attorney, supported decision-making, and guardianship, because I feel like the three of those are the ones that kind of get confused the most. And so it may be easier to kind of use an example. So this is Diana. Diana has schizophrenia. She lives alone. She's retired and does not work. Her adult son, Greg, helps her around the house, helps her if anything major comes up. Diana slipped on some wet tile a few weeks ago and is having terrible knee pain. So Greg goes with Diana to an orthopedic doctor's office to get it looked at. The doctor says Diana has a tear in a ligament in her knee, and the treatment is either, some steroid shots and regular physical therapy or surgery. Neither option sounds desirable. to Diana, it's causing her a great deal of anxiety because of her diagnosis, her age, her behavior in the office, the presence of her son, whatever. The doctor begins to question Diana's ability to consent to a certain course of treatment. So if we look at this scenario under supported decision making, let's say Diane had her son as a supporter. She would be able to use his support in the way that she wants to help her make that decision. So the process, which would be written down in her supported decision-making agreement, would allow the doctor to better understand how she has made that decision and recognize her use of her son as a supporter as a valid way for her to demonstrate that medical informed consent. So for example, if Diana knows that she gets stuck or that she needs help understanding what questions to ask, the son could provide support in that way to ultimately help Diana make the decision herself about which course of treatment to do. Looking at the scenario under a power of attorney, if Diane had previously executed a POA document naming her son as POA for medical decisions, or naming him as attorney-in-fact for medical decisions, the doctor could then look to Greg to make that decision on his mom's behalf in accordance with the language of the POA. And if Diana was not a fan of what Greg did, she could remove him as power of attorney and either appoint someone else or make the decision herself. Under guardianship, if Greg had been appointed guardian, the doctor would look exclusively to Greg to make a decision about which treatment to do. Now, hopefully, Greg would be following good evidence-based and supported decision-making centric principles of guardianship, and that he would look to Diana's desires and choices for how she wants to do when he's making the decision, but ultimately he would get to make the decision on her behalf. So if you think about it, supported decision making is, I make the decisions myself using a supporter. A power of attorney is, I appoint Amy to make decisions for me. And then guardianship is a court has appointed Amy to make decisions for me. So you can kind of see how those differ a little bit. So if you haven't guessed, less restrictive alternatives are the things that we discussed in a few slides ago. And if you weren't paying attention, or if you want a refresher, they include in Indiana, things like supported decision-making agreements, appropriate technological assistance, which would be that informal support, appointment of a representative payee or a healthcare representative, creation of a power of attorney. But basically, less restrictive alternatives, which are now in the guardianship code in Indiana law, means an approach to meeting a person's needs that restricts fewer rights of the person than with the appointment of a guardian. So we've talked a lot about how this concept of supported decision-making is kind of what we inherently do anyway when we're making decisions. So, if you're thinking about, deciding what kind of car to buy, most of us don't write down that, I'm going to talk to my brother, I'm going to consult Kelley Blue Book and Consumer Reports, I'm going to visit these 3 dealerships, and I'm going to look at reviews online before I make my decision. Probably not. Most of us just kind of do what we need to do to make a decision. But for those who need some additional support or structure, that might be a needed tool. So these supported decision-making agreements not only provide a reference point for the person who needs support, but it also provides structure to the supporter. And it can be used to show third parties like doctors or service providers or banks who may be questioning the person's ability to make decisions, that they are in fact able to make their own decision and have that be recognized, even if they are using accommodations or supporters in that process. So the new law in Indiana now has legal recognition for this. I don't want to read the entire statute for you, but here are some of the things that I want to highlight when it comes to supported decision-making agreements. So the person must have 1 or more supporters over the age of 18. The SDMAs must be entered into voluntarily, and the person must understand the nature and effect of that agreement. So basically what it does, what it doesn't do, who their supporters are, how they want that support to be given. And it also notes that the person can still have control over their decision making, even if they need support to do so. They are not required to use their supported decision-making agreement in every context of decisions that they're making, but it is there as a support if they need to do so. The person can change or modify their agreement. They can also choose not to trigger the use of their agreement. If the person has a guardian and wants to use supported decision-making, the guardian does need to consent in writing, but there is an option for that, at least on the form that we have developed as part of our project. And the supporter has a relationship of trust and confidence. So we want to stay away from treating supporters as fiduciaries. They did that in Texas. It created a lot of problems in finding people to serve as supporters. But basically what this means is that supporters can't be paid for serving as a supporter. Paid staff are able to serve as supporters if the person wants, but a best practice is to really have those paid staff serve as supporters in areas other than the services they provide. So for example, if the person wants their job coach to be a supporter, it might be best to have that person serve as a supporter in areas outside of employment, just to keep the roles separate as to when they are being a supporter and when they are being a paid service provider. A supporter is not able to access information about the person without the person's consent. So the person may need to sign a HIPAA or a FERPA release. Banks might also need additional paperwork to allow a supporter to have access to financial information if that's necessary. But a supporter does not have automatic access to that information. And then it also references how a supported decision-making agreement would work with a power of attorney. The power of attorney document should also reference the SDMA to make sure that both documents are recognized. And then to be valid, an SDMA must be in writing, it must be dated, and it must be signed by the adult in the presence of a notary. The SDMA must contain a separate consent signed by each supporter. We include those as an addendum to the document, indicating that their relationship to the person, their willingness to act as a supporter, their acknowledgement of their duties, and it expressly states that the supporter is not a surrogate decision maker for the adult. That way people know not to look to the supporter to make the decision. Again, if that's what the person wants, then technically, a power of attorney document might be necessary. So a revocation is in writing to each of the named supporters. So if the person wants to get out of that document, they want to do that. And then an SDMA terminates when the adult either passes away or whether they revoke the agreement. If all named supporters withdraw without any successor supporters being named, or if a court determines that the person doesn't have capacity to use that. So supported decision-making agreements in the law in Indiana also provide third-party protections for relying on or declining to honor an SDM agreement. So if a doctor relies on a decision made using a supporter, then that doctor should be protected from any consequences that the person might bring back about that. It also provides protections from liability for supporters, except in cases of fraud, misrepresentation, recklessness, or willful or wanton misconduct. And if anybody knows what wanton misconduct is, I would love to know, because I don't know if I have yet to see wanton misconduct in my days. So in Indiana, there's no special form needed. However, you do want to look for some common components of a form. Acknowledgement of the way the supported decision-making relationship will work, identification of the supporters and the areas of life where support is needed, the manner by which support should be provided, a way to reference or incorporate other documents or other supports that the person might be using, and finally, having an acknowledgement by the supporter of their role and responsibilities. And then lastly, the form is signed by the person and it's notarized. So if someone wants to know how to get started using supported decision-making or other options other than guardianship. So let's break down that process just a little bit. So for people currently under guardianship who want to move to a less restrictive option, their first step should be to an attorney, because there's no way to get out from under a guardianship without going to court. So Indiana Disability Rights and Indiana Legal Services and other legal assistance might be available to help look at that restoration of rights issue. But for those not under guardianship, those who are just generally considering what options to use, here's some steps on how to do it. So you want to learn more about the options, so going over all of those different options that are available. We have something that we do called the person-driven support worksheet that the person themselves fills out either independently or with assistance, where they start to think about the areas of their life where they feel that they need support, as well as how they feel they like to make decisions, whether they like a lot of information or whether they go with their gut or whether they look to the experiences of families and friends. There's all kinds of different ways to help people figure out how best to help support them making decisions. And then have others who know the person complete a support assessment as well, see what areas match, what areas don't match, and look for some of those common areas where areas of life where support might be needed. And then you also want to have the person think about who you might want to help you. There's a lot of really great qualities for circles of support. Obviously, in Indiana, it's got to be an adult over 18 if they want to serve as either a supporter, a guardian, or an attorney in fact under a power of attorney agreement. You want to look at the person's stated trust and their preference. Is this, you want to look at the length of time the person has known them. Is this somebody that they've known, just for a couple months, or is it, the woman who has lived next door to them their entire life? You also want to look at their relationship with the person. Is it a family member or a close family friend, or is it a former service provider? How do they know the person that they might be looking to help? You want to look at, are they likely to agree with or honor the person's choices? Are they available? Will they answer the phone if the person calls? Do they live close by so the person can check in with them if they need it? That's not, a bar. You don't have to physically be geographically located near your supporters, but you do want to make sure that they're available if they need to call on you for assistance. Are they able to provide support in the stated way? So, for example, if I say, I want support I want you to attend the meeting with me to help take notes about what's said because I tend to forget the details of what the doctor said. But I don't want you to talk. I don't want you to give input because when I'm in that appointment with my doctor, I want the doctor to look exclusively to me. So if I say that that's the way I want support, and you come into my doctor's appointment with me and you start jabbering away or start answering questions on my behalf, that's not providing support in the way that I want. Suitability includes both the person's expertise. Do they have somebody helping them with finances who knows things about finances? Do they have somebody, it also looks at, their character, their criminal background, their observed influence over the person as far as suitability goes. And then you also want to consider secondary or additional or backup people in case there's an emergency. All of these different things you can look at to help somebody figure out who might be good to use either as supporters or as attorneys in fact, or as potential guardians. So after you're done doing the assessments, you want to kind of go over the assessments with the supporters, start to develop a plan, write out your plan. We have a supported decision-making agreement template that we use. You can also consult with an attorney who can help write a plan. Then the supporters sign the consents, and then you want to sign the documents in the presence of a notary. And then we are big fans of proactive implementation, so making sure to share a copy with your regular providers so that they're aware of what's going on. Okay, so let's talk briefly a little bit about guardianship because there has been a change to Indiana law based on that. So under guardianship, a petition is filed, and generally attached with that petition is a physician statement. Now, the physician statement tends to vary based on the county, but generally it goes to the person's capacity, their ability to live independently or not live independently. And then there's also the guardianship registry form. So all of those things kind of go into that whole petition. There's got to be notice to interested parties. This includes not just the person who might be put under guardianship. There's also a list of potential family members that may need to be notified. Generally, a guardian ad litem should be appointed, and that the role of that person is to make recommendations to the court, not to advocate on behalf of the alleged incapacitated person. So again, the guardian ad litem is not serving in an advocacy role. They're not representing the interests of the person. They are providing recommendations to the court about whether or not the person meets that definition of incapacity, and if they do, who would be appropriate to serve in that guardianship role. So there's also a hearing. The alleged incapacitated person, they can have counsel, they can call and cross witnesses, all kinds of information is given to the judge, and then the court makes that determination as to whether or not a guardianship would be appropriate, and if it is appropriate, who should do that. And then the court will issue what are called letters of guardianship, which basically outline the roles and responsibilities for the guardian, and the guardian can use that document to show service providers, banks, doctors, all kinds of places that they do, in fact, have the ability to make decisions on behalf of that person. So within the petition for guardianship, and here's where the changes have been made this year. So you want to put the name, the age, and the address of the person, describe the nature of the incapacity or the reason that they're seeking guardianship, value, description of property, any requested limitations, the guardian contact information, the guardian interest, and names of any other person that the guardian serves, relatives, blood or marriage for notice purposes, and brand new, it must include a description of the petitioner's efforts to use less restrictive alternatives before seeking guardianship, including less restrictive alternatives that were considered or implemented, or if a less restrictive alternative was not considered, the reason why, or the reason that an LRA is insufficient to meet the person's needs. So what does that mean, essentially? So implemented, basically you would want to describe why a less restrictive alternative is no longer working. What has changed in the person's life where they had been using a power of attorney, but that's no longer working for them, and now they need to go to guardianship. You would just kind of want to describe what happened. And then for considered LRA, you want to look at the various options. You want to talk about, what skills are needed to make an LRA a viable option if that's possible. Can the person work towards an LRA in the future? All of that information is helpful to the court for them to be able to make that decision. Now, I want to be very clear, you are not required to use or try an LRA prior to filing a petition for guardianship. They do have that in some states, but not in Indiana. In Indiana, you just have to describe it and give the court information so that the court can make a determination. So one of the biggest questions that I hear about supported decision-making is, what protections are in place? And this applies to all of those other less restrictive alternatives. So what protections are there to keep people from making, a quote-unquote bad decision, or to keep them from being abused or neglected or exploited? So I want to address a few of those concerns. So there is a presumption of capacity that happens magically on a person's 18th birthday, where the state says, congratulations, you are now an adult. Now, I don't know about you, but there is nothing magic that happens overnight where you wake up suddenly being a functional adult. I'm in my late 30s, and I still don't feel like I always have a handle on things. But so here's an example, and recall that I am at best an adequate driver. Well, in college, where we all know that, great decisions are made, I decided to test fate by seeing how long I could go with my tank on E. And it didn't start out that way. I was late for class, didn't have time to stop. And then I was just, in a hurry to get home. But I went like 2 or 3 days with that needle, just pushing it on the E. And then finally, off campus on my way home, my car died. So what should have been a $20 fill up turned into, a $75 tow, to a gas station, a $20 fill up, and a really embarrassing phone call to my parents about why they were going to get a bill for $75. Now, after this incident, the state didn't take away my license. They didn't say I can only drive when I have over half a tank in my car. No, I was able to learn from my mistake. I was able to move on without having significant consequences placed on, my quote-unquote bad choice. And that's presumption of capacity. That's having dignity of risk. Unfortunately, people with disabilities are not often given that same dignity to make mistakes, and they may find themselves in a position where their ability to make decisions is questioned for a history of making, bad choices that many of us have also made. How many of you, and I can't see anybody's hands raised, so I'm just going to imagine, have ever heard or said the phrase, well, he's an adult, he can do what he wants. And it's usually a he, isn't it? And you'll notice that you never say it when someone is making a good choice. It's not, Bill sure is saving a lot of money. Well, he's an adult, he can do what he wants. No, we start to question someone's choices, not based necessarily on their ability to make decisions, but rather when someone is making a decision that we don't agree with. Here's an example. So my dad has smoked a pipe his entire life. It's a gross habit. It's unhealthy. It's expensive. It's just generally icky. My sister and I have constantly told him to stop smoking. My mom, his doctors, friends, coworkers, literally everyone in his life has encouraged him to stop smoking. But no one has ever said, you're making an unhealthy choice that a reasonable person wouldn't make, so I'm going to get guardianship over you because it's clear that you can't make decisions related to your health. That's silly. But people with disabilities are often held to that higher standard. They don't get that dignity of risk that my dad enjoys. They don't have their choices respected automatically by doctors or service providers. And this presumption of capacity, dignity of risk, is what allows us as adults to, eat cake for dinner and to not take our antibiotics as prescribed and to not work out and eat healthy like we know we should, to not wear bike helmets. It's what allows us to rack up debt and date the wrong people and do all of the things that really make life life. And this burden of low expectations is that we assume that people with disabilities won't make good decisions, or they don't know how to make decisions at all, so we don't even give them the opportunity to do so. And then we're surprised when they make a quote-unquote bad decision and have a knee-jerk reaction like, well, that didn't work. I guess they can never make a decision again. It's not how we treat the general populace, and it's not how we should treat people with disabilities either. I know many of us would not want our decision-making skills evaluated based on decisions that we made when we were 19. I certainly wouldn't. And people with disabilities deserve that same presumption of capacity, that same dignity of risk, that same ability to learn from their mistakes that we all enjoy. And here's a secret. It's not really a secret, but guardianship is not an impenetrable shield. It's not a chastity belt. It's not a bank vault. It won't keep somebody from walking out of a facility. It won't force somebody to take a medication. Bad things, unfortunately, can and do happen. It's a terrible part of the world that we live in. There's no guarantee of safety under any arrangement, including supported decision-making, including power of attorney, including guardianship. But that's not a reason to preemptively limit the options that are available to people in order for them to live their best, most independent lives. Instead, people with disabilities should be empowered to use their voice, have their voice respected. So that means if abuse, neglect, or exploitation does happen, having their stories believed, and then holding the perpetrators accountable. It's so much better to teach someone how to identify that toxic, abusive, or exploitive behavior than to rely on someone always being around to do that for them, because eventually they won't have a person in their corner, or worse yet, they'll have the wrong person. Lastly, Indiana is a mandatory reporting state. There is a requirement for people who become aware of abuse, neglect, or exploitation to report that to Adult Protective Services or law enforcement. And then finally, how do you fit into this discussion? So you want to talk early and often about options. You want to push back if you hear people encourage guardianship as the only option, especially if a less restrictive alternative might work. You want to encourage opportunities for decision-making, building decision-making into curriculum or treatment planning or services and supports, adding it in as performance goals, encouraging the person to be an active participant in the meeting, and then supporting that person's decisions, because nothing is more demoralizing than when you are working on building your communication skills. You communicate that decision and then having it ignored or people do the opposite of it. And then finally, making sure to refer people to resources so that they can learn more about options that are available. Here are some great resources to check out. Indiana Disability Rights has created a website. We are working on updating that website to provide even more great tools and videos and provide Indiana-specific information on supported decision-making. And there are some other great resources listed up there that might also provide some additional information. And with that, I am done. That is my contact information. You can feel free to reach out to me directly if you have specific questions or things that you want to talk about related to decision making. And with that, I
Awesome. Well, that was wonderful information. And for those of you who are listening to the call, as we stated earlier, this is a pre-recorded session. So any questions you have right now are not being directly answerable to Melissa. But what you can do is go ahead and type your questions in, and we will be sending those to Melissa for response, and then we will send them out to everyone who is in attendance. But just really quickly, Melissa, something that we've come up against here recently is we are finding that a lot of times providers or others are telling families that if they can't afford guardianship, then power of attorney is all they need, and that gives them the same rights as guardianship.
Mm-hmm.
So what exactly, how do we handle that? Because obviously, as you said, we do have some consumers where power of attorney is very much, a good situation. But we also have some consumers where obviously, they really don't have that. My understanding with power of attorney is that you have to be capable of giving someone that permission to make decisions for you. So if you're dealing with somebody who has some pretty severe disabilities and really does need a guardian, how does that work?
Right. So obviously you want to start with and look at the least restrictive option that's going to meet the person's needs. You don't have to automatically start with the least restrictive one, but you want to kind of, narrowly tailor what the person needs with the support that they need. So obviously there are different legal standards for power of attorney versus guardianship. So for power of attorney, the person has to have that consent to be able to appoint somebody to make decisions on their behalf. So that means they have to understand the nature of the document that they're signing. They have to understand that they know who they are giving that authority to and under what circumstances, and they have to understand, how they can revoke it or what their rights are under that. If the person is unable to really use a power of attorney, what could happen is if a service provider, if a doctor, if whomever feels that a power of attorney document is inappropriate, meaning that they don't feel that that person has capacity to appoint a power of attorney, the service provider can refuse to acknowledge it or refuse to abide by it and request the person get a guardianship or get a different mechanism for providing that input on the decision making. Now, obviously, some providers are different than others. Some are more or less informal. Some courts and counties differ in their practices. So, it really kind of depends on the county and the person, but they are completely different standards. They're completely different tools in the toolbox. And so they shouldn't be confused with each other. If a person truly does need guardianship, that means they are unable to communicate or effectuate choices relating to their care or their property, then guardianship really may be the most appropriate tool in that circumstance. But they are not the same thing.
Okay. And so obviously then we need to be working with individuals and families to help educate them and learn. And then it also, in terms of the differences between guardianship and power of attorney, my understanding is, obviously guardianship, whoever is guardian is the ultimate decision maker, whereas in power of attorney, the individual can still bypass that individual, can they not?
Correct. And again, it kind of depends on the provider's relationship with the person and the attorney in fact who's named. And it also depends on the language in the power of attorney document. So it could be something like if it's a finance thing where, I, Melissa Keys, am going to make all of my financial decisions myself up to $500. Anything over that, I agree to talk to my power of attorney and delegate, or my attorney in fact, and delegate to her the ability to make that decision about whether or not I can do that. And so based on the language, anything under $500 should not be covered by that power of attorney. I should still be able to make my choice myself. Now, I can also, go ahead.
I was going to say, so basically you really shouldn't just be printing off a POA from the internet in these situations and having people sign them.
Yes, that may seem very convenient and may seem very cost effective, but in order to truly get the person's wishes, you really wanted to tailor them to what it is they are trying to accomplish. And a person can also revoke it. They can rip it up. They can revoke it if they, depending on how revocation is handled in the document itself. But they can take it away. So if Amy is my attorney in fact, and I don't like the way she's making decisions on my behalf, or if I feel like she's not properly serving in my best interest, I can say, Amy, I don't want you to be my POA anymore. I want somebody else to serve in that role, or I don't want a POA anymore. So the POAs are a little bit more flexible, but you really want to look at how the POA is drafted. You really want to individualize it, and the person does, still retain rights to make their own decisions, and they don't have to exercise the POA. The POA mostly comes into play if A, the person wants somebody else to make a decision on their behalf, or B, the provider, mostly medical doctors or finance people, are concerned about the person's ability to make decisions themselves, and they're looking for that power of attorney relationship.
Okay. Well, I appreciate your time so much this morning. Very, very helpful. Definitely good information and something that we always need to be staying on top of, because I know things change. And in terms of supported decision making, that doesn't require going to court, or are there any formalized things that need to be done for that? I forgot to ask you that.
No. So supported decision making, it would be wise to consult with an attorney who's knowledgeable about it, just to make sure that the document complies with Indiana law. But basically, you can write it down. You can get it notarized. The notarization of it is what allows third parties to recognize it as a valid way to demonstrate that that a decision has been properly made. But you don't have to be formal about it. You don't have to write it down. You don't have to use it or exercise it all the time. But you definitely don't need to go to court. Now, there may be times where a court might suggest or encourage somebody to use supported decision making. So, for example, if somebody filed a petition for guardianship and it was alleged that the person could benefit from supported decision making instead of a guardianship, the court might say, okay, well, let's give supported decision making a try for a couple months. We'll circle back and see how it went. So in that instance, a court might be involved or have some oversight. But in general, just somebody who wants to try it out just needs to make sure that it complies with Indiana law. But otherwise, no court involvement is needed.
Okay. Well, again, thank you so much. We will get questions to you. I appreciate your time and your flexibility in making this happen. This worked out great, I think, being able to do this ahead of time. And we look forward to working with you again in the future.
Absolutely. Thank you.
Thank you. You have a wonderful weekend.
You too.
Bye-bye.